It's a criminal trespass, Judge.
Okay.
3 days and 2 days credit.
Mr. Williams. So you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You guys, I guess, have worked out an agreement. They're offering you time served. This is what you want to do. You need to understand that it's going to go on your record from now on. You're facing a minimum of 30 days in jail for any new cases that you pick up. You also give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers if you're not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Is this what you want to do? How do you plead to the offense, sir? You high right now?
I don't believe he's intoxicated, Judge, at all.
How do you plead to the offense, sir?
Trespass. Guilty.
Guilty, I'll find you guilty, send you to the agreement. I'll roll your court costs so you won't know anything.
Thank you, Judge.
Apart from Mr. Williams.
Yes, sir.
You know, you got the one life. All you're doing is you're racking up more and more charges. Sometimes you're going to see it's going to be really difficult to get a job, and it's already tough to be in your position now as it is. All you're doing is making life more difficult, man. Get on it. All right. Thank you, Mr.
Judge.
Williams.
Hey, Judge, Anna's kind of similar.
Good morning, Ms. Russell.
Good morning, how you doing?
How are you?
Great.
So it looks like to me, you are wanted out of North Carolina, specifically Wake County, for all felony probation violation, another probation violation, another probation violation, and a misdemeanor probation violation. So it looks like 3 felony probation violations and a misdemeanor probation violation. What's more is that you were on bond for a fraud case here. God, the bond was at nearly $500,000. It looks like that was just recently disposed of on the 7th of this month as well.
I got time, sir.
Well, 180 days state jail, I guess, right? So Amy, what's going on now?
Yes, so the manager solution is going to pick up on the 5th. We were just bring her out so we can watch her about the pre-sign waiver. If I understand.
So there's a pre-signed waiver.
Yeah, we already entered it on October 17th.
Got it. So a couple things you need to understand. Depending on where you get on probation, when you get on probation, especially on felony cases, you sign something it's called a pre-signed waiver. You sign a document saying, okay, look, by signing for this probation, I agree to waive formal extradition so that you can never fight extradition if you're ever picked up in another state, another county, or whatever. In that respect, even if I wanted to give you a bond, I can't, because you've already waived extradition as it is. So I can't give you a bond. We typically just wait. And as a matter, it's 30 days that they have to come pick you up, not the normal 14, because it's a pre-signed waiver. At that point, it's a 30-day wait that we give them for North Carolina to come get you.
Well, I came court day. I signed my waiver on the 16th. My day started on the 16th, the 14th. And they said they wanted to extra 5 days, but my mama talked to my attorney. They said they're not coming to get me, sir. It's old, 7 years old. They're not coming.
Well, and if that's the case, then at some
Oh,
once the
wait.
30-day runs, at that point they'll issue a nollie, and then they'll
Yes,
get out of here.
On the 16th, my day started on the 16th. I'm aware that I signed my waiver and they said that you signed off on it for an extra 5 days. They said they asked for an extra 5 days. My attorney.
It's still within the 30 days though, right, Amy?
Yes, yes.
It's still within the 30 days.
Yeah.
So it's still, I mean, we're not doing anything to you.
So the extra
That's-
5 days that they said that they want to come and get me. If they don't come and get me by what, November 4th, do y'all release me?
What's the date?
Her very last reset date is November 18th. Also, we're trying for that. So we have her next reset to be November 6th. Because they want.
Have you spoken to North Carolina?
Yes, and they're scheduled for November 5th, I believe.
So they've spoken to North Carolina. North Carolina is still interested in you, and they're indicating that they're gonna come get you. So I don't know who your mom talked to, but they're talking to the sheriff's office and the DA over there, and they've indicated,
Can you tell me why it's on the 18th and my day started on the 16th? I signed with you on the 16th. Can you tell me that, please? I signed on the 16th, sir.
So the 16th was the original waiver.
Yeah.
That was the 14 days, but then we had to get an extension, which is why we entered the.
so it's 5 days from the 14th. That's what it is. No. Remember, it's a 30-day window that they have to come get you, not the
Signed
14th.
on the 16th. I didn't go to court on the 18th. I signed on the 16th. That's what I'm not understanding. I got the papers.
Okay. I mean, it's still within the 30 days. Okay. So they have up to 30 days. Sometimes they need a little bit more time. As long as it's within the 30 days, it's fine. It's not an issue. But they have up to 30 days to come get you.
What you mean by another?
So I don't know what the actual day that they're gonna come. I have no idea. So I'm not gonna commit to an answer for you because I just don't know what day they're actually gonna come. It's just that they have 30 days to come get you, and that's what's gonna happen.
Talk to the prosecutor.
Don't talk to her.
So if November 5th, they don't come and get me, then what? I got to come back to court or what? That's what I want to know. I'm not
No,
understanding.
they have until the 16th of the following month. Theoretically, they have the 30 days to come get you. Now, we try to get them to come quicker, but sometimes they do, sometimes they don't. It depends on how many other people in other jurisdiction, other state that they have to come get. But they try to do everything at one time so they don't continue, because every time they come pick you up, it's $3,000 there, $4,000 there. So they try to do everything at one time to maximize spending, so they're not wasteful. When you get on probation, fulfill your probation, because when you don't, and when you end up with these violations, this is what happens.
I'm sorry. Thank you.
Right now, come on this way.
Wow, passive aggressive. Ay, ay, ay.
Thank you, Judge. Can I be
Thanks,
excused?
Anna. Of course.
Okay.
All right, good morning, everybody. My name is David Fleischer. This is County Criminal Court at Law number 5. We are here with regards to cause number 2499983, State of Texas versus John Gerard O'Shaughnessy. Today is the day set for trial. Guys, would you please announce yourselves for the record?
Michael Haddad for the state.
Alex Macias for the state.
Savannah Luna for Mr. O'Shaughnessy.
Okay. So first things first, it is 10/22/24, October 22nd. It's approximately 9:52 in the morning. We've started out this morning. Defense has requested a shuffle, so we're getting that into the works. It has also come to my attention, and I asked both parties yesterday, I think it was yesterday, if they had any pretrial or preliminary issues that they need to go over. At that time, they had indicated no. One thing has come up now. It looks like the state has a PowerPoint presentation that you're going to do for purposes of order,
Yes, Judge.
but you have an objection.
Yes.
State your objection.
Yes, so, if you don't mind. So for slide number 5 of the state, it's called refusal to provide a specimen. While I understand that that is the law, however, they only cited part of Texas Transportation Code 724.015, A1 and A2. And I'm objecting because this is going to confuse the jury. It says that if the person refuses to submit to the taking of the specimen, the person's license to operate a motor vehicle will be automatically suspended for not less than 180 days.
All right.
However, okay, yes, and
It's just not right. So if you can take that out, at least that portion out. If we take that, are you okay with the rest?
well,
Yes.
also for 724.011A, they cited part of it. However, with respect to y'all, they did not cite the full statute. It just says driving in a public place.
Can you put the whole thing in
We're
there?
gonna delete the slide.
Yes, Judge. The slide will be
We're gonna
deleted.
entirely
Yes,
delete the
Judge.
slide.
And then if you go down a little bit, I had another one. Yes, and then they have what is now marked as slide number 8. In it, they put what I would say random it says Texas County Court Statistics, January 24 to September 2024. And it's circling the total cases in the docket, total convictions, and total acquittals of, and I don't know where this is from, so I don't know how reliable this is. And second, it's going to inflame the jury because it says total convictions. And what it doesn't say is that if you look at dispositions by the jury, it's 376, and acquittals by the jury is 271. Instead of circling that, they have done a full list and tried to show total convictions of 80,603 versus acquittals by the court and jury of 367. That is not an accurate
Why do you
reflection.
have statistics up there?
In your honor, the main point of that statistic, just to demonstrate the nature of the justice system where there are convictions and there are acquittals, to demonstrate that the burden of proof is met throughout the state.
I mean, I don't think it's really.
In your honor, yes, that's the main purpose of that. It's from the Texas state there.
Yeah, I think it can be misleading, and, statistics can be manipulated in any way to show anything, and, if you don't cite a source, we don't know where.
We'll delete the slide, Judge.
Okay.
Yes, Judge.
Anything else?
Yes, sorry.
This is a new one?
Yes.
Okay. We've got the news. She shuffled, so we've got the new one out.
Punishment.
Thank you.
Did you have any objections besides the first two statistics?
Yeah, I couldn't play that. It looks highly inflammatory to me. I don't know if we can let the judge see it.
Talking about.
It's a burden of proof slide. Have you seen it? It shows a video clip. It's like some pirate or
Your Honor.
terrorist holding a knife like this, but I haven't been able to play the video, so I'm not really sure what it.
Can you show it to them real quick so they can see it?
You got creative coming up with all. This is all like off script, right? You put your work in.
The portion would be.
Does that have sound?
Yes, it does. Let me.
Oh, it's Indiana Jones.
It's Indiana Jones.
Oh,
Who can object to Indiana
Indiana
Jones?
Jones wrong. Come on, it's my hero. God.
It was like, what happened to him or something like that?
Correct. It's just
Is that what you're gonna ask? Like,
correct. Can you tell despite not
oh,
seeing
that's
that?
fine. I
Yeah.
can't object to.
Okay.
Boards.
Anything
Okay.
else?
Were there-
He deleted the
And
punishment.
I will delete
The
those
punishment,
statistics on there.
The only other thing I would put on the record is, I understand Mr. Macias is practicing under a supervised bar card. And he was gracious enough to send us that letter. Miss Luna was the same, and I looked up the rules about what they can do. And some judges didn't think she was able to do. It is from the state bar, and it says that you must be practicing under a supervised attorney, but they actually list Ryan Free. It says supervising attorneys, and it says Ryan Free. And that's the only attorney that the state bar lists can be supervising him
It can be supervising Alex.
on his supervised
What is that?
status letter from the state bar.
He's another chief judge.
So we looked at this heavily. We had a long conversation with Judge Wright. There is a provision for remote, just to be completely candid, for remote supervision. And I actually called the state bar about that, and Miss Luna was in here trying to obtain a reset. I was across the hall, and they said there's no problem with that. If she can contact you by text, she can call you. It's not a hearing. So that was remote supervision, but for me to not sit with her during a trial, you can't remotely supervise them throughout the entire trial. They'd have to be on the phone with you the whole time.
So you're
on Zoom.
objecting to his presence then?
Yes,
So,
I don't think it allows for him to try a case. Just going by the letter, it says specifically Ryan Free. It's the only attorney listed as the supervising attorney.
So Floyd, can you do me a favor? The statute that allows Alex to practice under a supervised attorney, does the wording state that And as long as there is a supervising attorney, or is it the only the person that signed their bar card?
Show me what you have so I can see it.
Yes, here.
It's not in the, it's not a statute, it's in the, just,
It says-
Yes,
disciplinary
my
rules.
apologies, yes.
I think if it said the Harris County DA's office, you know, it would have been.
And
better.
with respect to everyone here, and I don't mean to be rude,
Judges,
it also has to be someone that's been practicing for at least 3 years to supervise him.
Do you want me to email this to all the parties?
Yeah, or show me what you're referencing.
So where did you type to?
I typed in Texas student bar card and it says supervising bar card.
So then it might be that you might have to try the case, Mr. Haddad, and then Alex sits kind of, second chair with you. No, Tyler, you might have to try it against Mr. Haddad is,
Alex is way too
No.
prepared, so. no,
careful
just-
what you wish for, as they say.
I mean, I just think it's an issue that everybody should be aware of.
And I mean, if you're right, then you're right. I don't know. I've not seen the rule and I didn't know what his actual status was until now. Then you just said,
I didn't until last
So-
night either.
And so this is rule. These are called the rules governing the supervised practice of law by qualified law students and qualified unlicensed law students, law school graduates in Texas. And then if you go to rule,
Alex, are you still in law school now?
Yes, Your Honor,
What year are you?
a third year.
and if you go to rule 4, it says, subject to the approval of the presiding judge, administrative officer, arbitrator, or other hearing officer, they can appear in any trial, hearing, arbitration, or proceeding on behalf of a client, provided the qualified law student or qualified unlicensed law school graduate has obtained the client's consent, notifies or has previously notified the court of the client's consent, and is accompanied, whether in person or by remote means, by the supervising attorney. And then if you go to rule,
But there's no client in this respect. You know
yes,
Right.
but,
what I mean?
Yes.
This is,
and then the second part was about rule, I'm sorry, that was rule 6, and this is rule 7. I
Do
struggle
you
with Roman
do you want me to
numerals.
email?
because, well, the spirit of that is with respect to if you're actually representing an individual person as opposed to the state.
Yes, Your Honor, I was just, if you go down to rule 7
Okay.
for supervising attorneys, the supervising attorney has to be an active member of the State Bar of Texas in good standing who has practiced law in Texas for at least 3 years. And so
Has he not practiced law?
I have no,
And
and
Your
that's what
Honor-
I was asking if he,
Haddad, how long have you been
No,
practicing?
2, Judge, but I'm reading some of the rule. One moment.
Yeah, and there's a duty to immediately notify the state bar membership department if the lawyer no longer meets those requirements of these rules. If you give me your email, or did you already find it? Can you tell me?
It's,
I mean, it's David underscore, right?
let's see, yeah, first name first and then last name, underscore last name at CCL. Yeah. It's okay.
I understand.
No one's gonna do anything bad. Do you want to reach out to Beadle and see what he says real
Can you
quick?
give me one moment?
Of
Judge?
course, take your time. Just not too long because we got the jury, but yeah.
So, Judge, I've spoken to Ryan. He's willing to swap courts with me for the trial, so Alex can try this case.
Okay,
So I'm gonna go to court 11. Ryan's gonna come here. This case is gonna be tried with Alex.
perfect. Okay, there you go.
Do you, Tyler, do you have any objection to that on the record?
No.
Ryan coming? Okay, sounds good.
Sorry.
We'll get that done. No
Seems like-
problem.
You don't have to apologize. Just do what you do.